first thing we can talk about is just for those who aren't so familiar, could you talk a little bit about the original purpose behind parole in our justice system and how it's being applied, presumably unjustly today?
Sure. So I want to backdrop all of this. Hello, everyone. I'm Alexa Van Brunt. I teach at Northwestern Law School, but I teach a clinic, which means that all of my practice is real practice. I am a full-time civil rights attorney in Chicago, and I teach as well. But I think it's important to know that all the answers I'm going to give are at the backdrop of as a practitioner, as a practicing full-time attorney, mostly in federal court in Chicago, but some state law court. So on the parole question, my colleagues and I have been looking at parole systems for many years in Illinois, and parole has been around for a long time. As with many things in the U.S. legal system, there were precedents for this in England. In the common law system in England, there was parole, whereby people could get out early from prison or jail for good behavior. And that was essentially parole. And that was imported into the US system, used as early as the 1870s in New York, and was adopted by most states by the early 20th century. You got an indeterminate sentence, and you could get out early if a parole board or some authority decided that you were rehabilitated, meaning you had acted well in prison and improved your prospects. I think the quintessential cases that most people are familiar with are from Shawshank Redemption, where in character Morgan Freeman goes up before the parole board. That changed in most states across the country in the 70s, when the states moved to a determinate sentencing regime, meaning you had to serve an entirety of a sentence, and then after that you were also put out on parole. So it wasn't a way to get out early, it was a part of your sentence. It just meant you were being supervised in the community instead of behind bars. But what it really looks like on the day-to-day is another form of incarceration. People who are on parole in Illinois, it's called mandatory supervised release, and they are subject to just tracking by the state. They often are on electronic monitoring or GPS monitoring. They have a whole host of conditions that makes it incredibly difficult to get back into society, to get a job, to support their families, which just makes it more likely that people might be put back into prison. Because every time they violate one of those conditions, whether it's coming home after curfew, not following the strictures of electronic monitoring, they can be thrown back into prison to serve another set of months or years. And of course, like everything in the criminal legal system, it impacts people who are Black and Latinx much in disparate ways to white people. Many more people who are on parole are Black and Latinx than white. As a result, they're more likely to be put back into prison. So it really is a revolving door. And what we've been trying to do is push for more fair procedures in revocation. So people have lawyers if they're going to be revoked and thrown back in prison. But ultimately, just the abolition of parole entirely would be the best outcome, because it's just another form of unjust monitoring by the state and really does not lead to rehabilitation in any form, and in fact inhibits it. So I have a lot to say on parole, but that's it in a nutshell.
So bottom line, you don't think it's effective to begin with? No,
I think it's effective, racially biased, and doesn't do what it says it does, which is to rehabilitate and help people reintegrate into their communities after being in prison.
So the MacArthur Center is pushing ultimately for it to just be abolished. Is that right?
Well, what we do is, so the MacArthur Justice Center has multiple offices. My Illinois office, where I work, I'm the director of the Illinois office, and the St. Louis office in Missouri have both brought class actions against the parole systems in our states to try to make the systems fair, to make it harder for the state to revoke people, to basically gum up the works about parole. We are seeking to broaden that work on the national scale. We'd like to bring similar lawsuits in other states. So we're lawyers, we're not policymakers, and we don't do lobbying or legislative work. But it is true that if you make parole revocation more expensive, more onerous, actually provide people due process before they're thrown back in prison, the prison system's more likely to revoke fewer people. So we're hoping to basically stop the revolving door, and hopefully down the road, that work will dovetail with the work of advocates and legislators who should consider the abolition of parole. And we hope that will happen down the road, and we're just trying to do our bit to support it.
So while we're on this topic, could you touch a little bit on what a plea bargain is? Because there's a lot of talk about how plea bargains are sort of deceptive in the sense that, you know, someone will end up being charged for, let's say, weed possession, and then they like what actually shows up on paper is different from what they were actually originally charged for. So there's some sort of discrepancy in that way.
Yeah. So plea bargains, so I'll caveat all of this with the fact that I'm a civil lawyer, but I do issues that touch upon all phases of the criminal system. So my knowledge of criminal issues is limited to how it impacts our civil issues, I think. So plea bargaining is generally a really coercive system. People plea bargain often to get out of jail or because they've been sitting in pretrial detention for months or in Cook County years. Similar situations exist in other big cities. Obviously, people are probably familiar with the state of affairs at Rikers. They're really awful places to be, many big jails, small jails as well. And so people often plead guilty to a lesser offense, something they weren't charged with, in order to get out, either to time served or to go to prison, and in some cases have slightly better circumstances than in the jail. We look at it because of it touches upon our work in relation to our bond reform work, pretrial detention work. It is very much the case that many more people are detained pretrial than should be. People are presumed innocent. They should be able to be in their communities on the outside, able to help fight their case. But because many people are in on unaffordable cash bonds or no bonds while awaiting trial, the plea bargaining coercive aspect comes into play, and they end up pleading guilty. Whether or not they did it and whether or not it makes sense for them in their case, it's just, there are a lot of outside structural forces that come into play in plea bargains. So we often keep this in mind when we're trying to shoot for bail reform, pretrial detention reform, so that very few people actually should be detained pretrial. And that's one benefit, is that people will not be pushed to plead guilty to something and then can take their case to trial, which is generally could be really beneficial for many people who are facing charges.
So if I understand you correctly, it's sort of the incentive to plead guilty is strong enough where a lot of people that are actually innocent end up pleading guilty. And
whether they're innocent or not, it really just is an unfair process. You know, they are deprived of their day in court to challenge the evidence against them, to challenge the state. But yeah, it's true that innocent people also plead guilty. I do wrongful conviction damages cases, meaning civil lawsuits for people who are wrongfully convicted. I have a huge problem with that in Illinois. And some of my clients pled guilty to the charges they were obviously innocent of, because they did so to escape a worse fate, be it the death penalty, which was still in place in the 90s and early 2000s, or a life sentence. So pleading doesn't tell you very much about what actually happened in the case. And it really is, it can be a really coercive, unjust maneuver.
Mm-hmm. So as far as police accountability is concerned, this is sort of a loaded question, but obviously your center is focused on all sorts of issues of injustice. Yeah. However, I think it's pretty fair to say that qualified immunity might be at the center, or might be one of the most pivotal issues in police reform and justice reform in general. Could you just talk a little bit about how you see that debate and where you stand on it?
Sure. So when it comes to police reform, it's a really complicated, multifaceted issue. If we work often with coalitions of community organizers and advocates, and their approach to issues relating to police is very different from the approach taken by many lawyers. So if you are asked a typical person who does organizing in Chicago against the growth of the police force, they would certainly not say qualified immunity is the answer to police abuses. It would be, let's take back some of the massive amount of funding. Chicago Police has a $1.9 billion budget coming up in this next year. And let's direct those resources to non-law enforcement responses for people in mental health crisis, things like that. And we are very supportive of those interventions and ultimately, defunding many of the aspects of law enforcement. But if you're talking about, ways to hold people in law enforcement accountable in a court of law and barriers to that, then qualified immunity is a huge barrier. It basically says that an officer can get off scot-free from a lawsuit alleging a constitutional violation, even if they committed that violation, if there is not an exact case on point, what's called clearly established law, that looks a lot like your case. So the officer, so that you as the plaintiff can say, this case is directly on point. The officer was put on notice that what they did was unlawful. There's clearly established law, so they should be held liable. This case should go to a jury. Qualified immunity is not Congress-made law. It is a law that was made by the court system in 1982 by the judges in a Supreme Court case. And it was made for policy reasons, the misguided belief that if officers didn't have this kind of immunity defense, then they wouldn't act when they should in split-second scenarios. And really, first of all, the Supreme Court should not be making policy decisions. That's the job for another branch of government. And second of all, it just has no basis in the common law, and it actually, the policy basis is wrong as well. It turns out that, as you can imagine, by common sense, most police officers are not reading the latest appellate law or a Supreme Court law that's being handed out. So this new law that comes out is not putting officers on notice. So all qualified immunity does is create another barrier for people to be heard, for people to bring their grievances, and often serious grievances where people are shot or harmed by police, to the court system to vindicate their rights. And so that actually, it doesn't serve any purpose, and it's not founded in any public policy or common law. So it really should be eradicated. And there's a big movement, as many are aware, underway to eradicate it.
Yeah. So one of the things that I think is interesting about it, so, coming at it from, like you said, I mean, it's coming at it from even a textualist standpoint. There really isn't text to support qualified immunity, and it really is, as you mentioned, it's a very prime example of judge-made law, right? It's something that's been developed, like you said, for the past 2-3 decades. And interestingly, though, and I want to get your perspective on this, is that it's one of the few things that, and I just learned about this too, it's one of the few things that the court, so if you view the court as a political institution, as 6 conservative justices, 3 liberal justices right now, qualified immunity is one of the few things that in the last 3 decades has really not been challenged by the court. The only justice that's really even said much of anything about it, or at least dissented in the most recent case, was Justice Thomas. Expressed this past year or this is 2020. He's obviously aware of the public debate over it, and he's aware that the court probably should, if anything, put the decision back to the legislature.
Right. I was going to say the fact that Justice Thomas is against qualified immunity is, I think, a sign for optimism about getting rid of it. I agree with probably nothing else that Justice Thomas believes as a judicial matter. But the right and left do converge in very interesting ways on qualified immunity. Originalists can agree that there is no basis for qualified immunity in the common law and originalist doctrine, whereas progressives can also agree as to the lack of originalist foundation, but also as to the bad policy and the bad outcomes that it creates in hindering people's access to the courts. So my colleagues who are in the appellate team at MacArthur often actually use amicus briefs from the Cato Institute, which is a left or a right-leaning institution, against qualified immunity in various appellate cases, because the Cato Institute, just like many more progressive left-leaning institutions, thinks that it should be abolished. So I actually do have hope that we will get there. The court has not actually totally backed away from getting rid of qualified immunity. In a recent case, Taylor v. Riojas, it actually emphasized that some constitutional violations are so obvious, are so terrible, that you don't actually need clearly established law in point to put an officer on notice that it's against the law. And that's a really good sign, because in this terrible era where you need the exact case, there you can point to something that's specific, factually specific, and very closely analogous to your case, it's really great that there is at least this out where you can say, okay, there's not a case on point exactly, but this is so bad that any officer would know it was against the law. So there's hope. And I think at some point we'll get there and we'll chip away at it. And I do think at some point it will be no longer part of the judicial doctrine, but we're not there yet. And at this point, it does come up in every single one of my cases and is a really strong reason why cases can be dismissed prior to going to a jury.
Mm-hmm. Yeah, no, just to underscore what Justice Thomas said, as you mentioned about the test, he said qualified immunity doctrine appears to stray from statutory text. And then he goes on to say that there's likely no basis for this, as leading treatises from the second half of the 19th century case law until the 1980s contain no support for this clearly established law test. So he's clearly against it. And then lastly, so before we go to the personal questions, do you see, as much as you know, you're obviously against qualified immunity, and you know, even just from a purely textual standpoint, it doesn't seem like there's basis for it. What do you think is the most charitable argument for qualified immunity? So how do you respond to people that say that actually qualified immunity is necessary for officers to do their job?
Yeah, well, so there are 2 points that often get raised, and I'll just play the argument, raise them as straw men to knock them down. One is that if there wasn't qualified immunity, police officers would be bankrupt by police misconduct lawsuits, that every time the floodgates would open and no officer would stay on the job because they would constantly be at risk of losing their pension and their paycheck for reasonable mistakes. Well, that's wrong for 2 reasons. One, the Constitution, establishing a constitutional violation is already a really high hurdle. It is not easy to show that officers acted unreasonably under the Fourth Amendment, because courts give officers really all the leeway in the world to establish that they were acting reasonably. The courts can't look back with 20/20 hindsight. They really do give the benefit of the doubt to officers in those cases. So it's not easy to get to a jury and win those cases, even without qualified immunity. But the second important point, and this has been made really clearly by Professor Joanna Schwartz, who's like the foremost scholar of qualified immunity in the country. She's at UCLA. She did a study of police departments across the country. And across the country, it is very clear that police officers do not pay any damages awards that come out of these cases. They are almost uniformly paid by insurance or in some way by government. So officers are not paying these suits out of, or these cases out of their own pocket, and thus that shouldn't be a reason to keep it. The second point people make is that it protects officers from being held liable in unique circumstances. For instance, when a unique type of weapon is at issue. And again, that just doesn't really hold water, because again, the Fourth Amendment standard is so onerous and it takes a lot for a plaintiff to establish it. In all cases, law enforcement are receiving training, simulation on how not to violate the Fourth Amendment. So they are trained already in reacting in different situations, different use of force situations. But just adding qualified immunity doesn't in any way provide a added layer of protection for police officers. And all it does is, as I said, and we'll say ad nauseum, prevent people from seeking the access to the courts they're entitled to under the law.
Fair enough. So now we'll talk a little bit about, well, what's happened since Brown. So
yeah,
so as an undergrad at Brown,
yep.
You know, we'll start with just what were you envisioning as an undergrad, and
yeah.
Did you have anything specific in mind before you graduated?
Yeah. Well, so law was always in the back of my head. I was a sociology major. I focused a lot on international sociology. I did the thesis based on a study, including a 1-month field study in Lesotho in Southern Africa, There was always the idea that law school, yes, but maybe academia, maybe some kind of social justice policy research. I always knew I wanted to go into social justice work of some kind. It was just where. So after graduating, I graduated in '04. I took 2 different jobs to try to explore those different options before deciding on law school. So one was as a research assistant in an education nonprofit, policy nonprofit. And that kind of quickly put the kibosh on the academia route for me. I realized that I felt too disconnected from the issues. That is great work. It was really interesting research and policy. The policy publications that came out of it were really top notch, but it wasn't for me. So then I went the opposite route, and I was in DC, and I moved to New York and worked as sort of a social worker in an alternative sentencing program in the Bronx courthouse. And that really did solidify my interest in criminal legal system work. I didn't think I could do social work. My sister's a social worker, so I am really in awe of social workers, and we work closely with them. I think it's an amazing, amazing profession, but I didn't have it. I was burned out. But it did make me realize that I wanted to pursue law. So I went to Stanford, graduated in '09, did mainly international human rights law for the first couple of years at law school, was very much interested in international criminal law. I went to the International Tribunal for Rwanda, which was still ongoing at that point, one summer, and worked in the chambers there in Arusha, Tanzania, worked at the Open Society Justice Initiative the second summer. So I was pretty set that I was going to do international human rights law, either in the criminal or civil sector. But the more con law I took at law school, and the more I did work on constitutional law cases, the more I came to realize that I wanted to learn how to be a litigator, and that I wanted to practice on the ground where my clients were with me directly, and that I wanted to learn how to operate in the US court system. So I sort of pivoted from international human rights to domestic civil right or human rights or civil rights. And that's where I was when I graduated from law school, was a decision that maybe I'll go into the international sphere down the road, but I wanted to learn the ropes in the civil land in the US first.
No, so I mean, it clearly you took a little bit of time after Brown to figure things out,
Yeah.
which I think that's a good idea. I mean, personally, I'm going to do that myself.
It's helpful.
So.
It's helpful. I'll also say law school feels more manageable after you've been working. It feels kind of like a nice break as opposed to something that is pretty onerous. And it is. Law school is a lot of work, but it also is a really good time to meet new people and to kind of hone your interests after you've been out for a couple of years. So I'll say I highly recommend taking some time to figure out what you want to do before you go. Even if you're dead set on law school, I think it's valuable. It helps focus your interests once you're in grad school. But I love law school. I thought it was really fun. I met a lot of fabulous people.
Even the first year?
Yeah, the first year was tough, but we were all in it together. And again, I was coming from full-time job and commuting, and it was really hard. I was making no money. So actually law school was like, okay, now I just have to study and join student organizations and volunteer. And I felt really good and liberating, and I felt like I was in the right place. So I actually really enjoyed law school for the most part. And I do think that 2 years off had something to do with that. I think it changed my perspective a little bit.
And so you ended up clerking, right?
I did.
Judge Thompson.
Yeah, Judge Myron Thompson. So he is a district judge in the Middle District of Alabama, in Montgomery, Alabama. He was appointed as a judge in his 30s by Jimmy Carter, so one of the youngest judges ever at that time, and the first Black sitting judge at the time. And he it was just he's a phenom in the civil rights world. He's issued really kind of groundbreaking opinions on prisoners' rights, police misconduct, and civil rights generally. He's been overseeing certain consent decrees that are decades old relating to desegregation in Alabama. My con law professor, Pam Carlin, who has been in and out of the Department of Justice and Civil Rights for some years when she's not teaching at Stanford, pointed us to Judge Thompson in our con law classes, and like, he is an example of what amazing judicial thinking can be. His opinions are really well written. I still cite to them in my cases now. So I wanted to be in Montgomery. Had never been to Alabama, but I packed my bags, took a road trip from Wisconsin, where I'm originally from, and ended up in Montgomery for a year. It was a terrific experience. It solidified my interest in civil rights. And I, knew from then on I wanted to do impact litigation relating to criminal legal system reform specifically, and applied for jobs after that with that focus.
So what did you go into that clerkship thinking? Were you thinking, this could end up being like a lifelong mentor to me, or?
Judge Thompson, yes. I mean, I think what I also gained out of that, definitely, you always go into clerkship thinking, I hope I have a good relationship with the judge. But I think potentially just as important, and certainly for me, is your co-clerk relationship. There were 3 of us, and we sat in a room from 7:30 a.m. till 5:30 p.m. every day, typing opinions together and doing legal research. We became very close friends, and we also ended up becoming close friends with other young attorneys in the Montgomery area working for Brian Stevenson's organization, Equal Justice Initiative, Alabama Appleseed, the ACLU branch. You kind of find your people wherever you go. And so it was a really nice experience and really nice, springboard on which to launch a career. And my co-clerk, one of them, Jake Howard, is now the legal director of MacArthur's Mississippi office. So now we're colleagues. He can't get away from me, I guess. And it's just terrific. It basically solidified lifelong relationships. And I'm really, really grateful that I took a little bit of a leap of faith there.
So obviously that was a highly worthwhile and almost like career trajectory changing experience to clerk. Yeah.
It was. I mean, I think everybody should do what feels right for them. For some people, it makes sense to go do a fellowship at a legal services organization or nonprofit. For some people, they have a lot of loans to pay off because law school is insanely expensive. So it makes sense to go to a law firm for some years, and then maybe they make a pivot to social justice, public interest work, and they continue the pro bono work while they're at big law. As a clinical professor, I have students who go all different routes, and it just depends on what makes sense for them. And I think it's just important to note you can get where you want to go a lot of different ways. And I felt a lot of pressure on me when I was, 26 years old, that I had to pick the right thing or I would mess up my entire career. And that's just not the case. We work a lot of years nowadays, and we pivot a lot too. So it's important to just, I think, not put too much pressure on yourself as you try to figure out what works best for you. But certainly clerkship was a great experience for me. Great training in writing, legal writing in particular, and helped me in my first job.
Mm-hmm. And so could you talk a little bit about your pro bono work? And because I think, so it took a couple months to schedule you, and that's partially because you mentioned some sort of trial. Could you just talk about that a little bit?
Yeah, so actually, as I said at the outset, I'm mostly a practicing attorney. I just have a full docket of cases, and the MacArthur Justice Center is a nonprofit, so I just receive a salary. So any money we make from cases goes back to the organization to fund future cases. So I don't necessarily call it pro bono because it's literally just my job. But we teach students, so students work with us on those cases. That's the clinical model. Most law schools have clinics nowadays, and this is ours. So we have students who are assigned to different cases, police misconduct cases, prisoners' rights cases, some of our appellate cases, and they do the legal research, and they do the writing, and they do drafts, and they just help us with these cases. But in any event, yeah. So when I had to push back the first time, it was because we were set to go to trial in a wrongful conviction case. My client had served 20 years in prison, arrested as a teenager for a crime, not only that he didn't do, but he so clearly, obviously didn't do, because he was in police custody on a minor disorderly conduct charge at the time of the murders. So police had records proving that. They knew he was innocent, but they had coerced his confession already by the time they found those records. And so they just doubled down and went ahead with his prosecution. It's pretty egregious, not atypical in Chicago and Illinois, where we have one of the highest rates of false confessions in the country. at least historically. So we were on the eve of trial, and I was actually, just gearing up for that after the holidays. And it looks like that case, it got pushed back because of Omicron, but it looks like it's going to settle. So knock wood. But we have those kinds of cases, as I said, cases challenging prisoners' rights abuses. Solitary confinement is a big area for us. Suicides in jails and prisons, police shootings and abuses, protester rights, pretty much anything you can think of that touches on the criminal legal sphere and that implicates systemic injustices, we try to tackle when we can. So it's a wide field of cases.
Right. And I guess this is one of the final questions is, so how do you respond to the idea that a lawyer or someone with a law degree has a better chance or ability to affect change in social justice than someone that otherwise lacks that credential? Do you agree with that?
I don't ascribe to that model at all. I find that model very outdated and something that I think we as lawyers have to work very hard to overcome, because I do think there's this traditionally deeply held belief that lawyers are somehow superior in enforcing rights and in effectuating change. I think we bring one set of skills to the table. I think it's great that we can bring lawsuits, but that lawsuits are best used when they can help bolster and propel change that's already underway and being effectuated by people who are deeply and personally impacted by the issues and organizing around those issues. So our most effective work recently has been in coalition with impacted people organizers. So if we can bring a lawsuit that will help push for a policy change that organizers and advocates are already pushing for, that's great. And I think litigation is something I'm good at. It's something I have a skill for, but I recognize that it is one tool of many, and it shouldn't be lauded above others, and that it's important to come into this profession with a sense of humility, and that anything else really does a disservice to clients and the communities we work with. And I think that's true whether you're in big law, like corporate law, or whether you're in civil rights law or legal aid work. That respect and recognizing that we are ultimately service providers. It's a service profession is really important.
Right. No, that's a good comprehensive answer. So here's my final question, which is, so I'm going to grant that everything you just said holds. If that's all true, that that it sort of doesn't put you at any better position to affect change.
Are you going to ask me why should you go to law school?
Exactly. So why should someone go to law school then? What do you think is the best motivation to do so then?
Right. So everything I just said, I don't want to say that I don't want it to make it seem like I believe there's no value to the law, because obviously I do. I dedicated my life, soul, and so much time to it. I think it's important to be realistic about your interests, your skills, and what you actually want to achieve. If your skills and interests lie in the law, then that's fantastic. And then you can do so much good through lawyering, whether it's in a traditional courtroom or maybe less traditional models of lawyering. There are many, there's lots of talk now about grassroots lawyering and social movement lawyering, whereby lawyers play a less traditional role in pushing movements forward. So that exists. If you're working in a traditional big law format, there's always pro bono work, and it's really important work, especially for prisoners who don't often have representation. But if you're just doing law school because you're not quite sure what's next, and that just seems like an obvious, easy option, I would just suggest working for a couple of years, volunteering for a couple of years, doing something to kind of try to hone in your interests and skills. Just because it's not just a lot of work, it's so expensive. It's so expensive. And it's going to be real. I'm still paying student loans from law school. So I think it's important just to really take a deep look at what your interests are, what you bring to the table, and what you want to achieve, and then see if that aligns with the law. Recognizing that the law looks very different now than it did maybe 50 years ago, that there are other outlets for achieving justice and reform than just traditional courtroom advocacy. So that still is very important, including in the public defense model. I just want to quick caveat and say that.
Yeah.
But I think it takes a lot of a deep thought and practice, real practice can help you make that decision too.
Yeah, no, that's a great answer. I think, I think that wraps it up. Thanks so much for coming on. We appreciate it.
This was a really terrific opportunity, and it's always good to reconnect with Brown again. I do love that place. Thanks so much, Thomas.